Hello, everyone, and welcome to this Logical webinar. I'm your host, Robert Hilson of Logical.com. And today we will be addressing what, to my mind, is a very important, though, as we'll see, an undercovered issue in law and legal technology, and that's the issue of taxation of e-discovery costs. So if we move on to the next slide, this is our agenda for today. We'll first briefly touch on an issue that arose during our last webinar, which is the idea of what we're calling the Rule 34 compliance tax, and how parties who are specifying production formats in accordance with Rule 34 might be exposing themselves to additional post-judgment costs. So we'll talk about kind of the implications of that. Then we'll dive into the history of cost taxing in U.S. federal litigation and how our procedures and laws work together in a way that allow prevailing parties to recover certain litigation costs. And then we will address two landmark cases that have reshaped how most federal courts address taxation of eDiscovery costs specifically. And then finally, we'll look at some cases that serve as, if not as counterpoints, certainly caveats to those two important cases, Race Tires America and Taniguchi. And then finally, we'll leave you with some practical takeaways. So we're very pleased to be joined today by the Honorable Joy Flowers Conti, the Chief District Judge for the U.S. Court in the Western District of Pennsylvania. Judge Conti's resume and list of achievements are way too long to go into here, so I'll just hit a few highlights. She is a former president of the Allegheny Bar Association and former chair of the Allegheny County Bar Association's Young Lawyers section. She also served in the House of Delegates of the American Bar Association and as president of the Historical Society of the U.S. Court of Appeals for the Third Circuit. She is also a member of the federal court pertinent to our discussion in Pittsburgh that is among the leaders in e-discovery and that has set the course for issues related to e-discovery cost taxation. Judge, thank you very much for joining us.
It's a pleasure for me to be with you.
It's a pleasure to have you here. And I should say to our audience, she has a jury deliberating, so if she has to step out for a minute, we'll let her do that. But Judge Conti is joined by Mike Simon. Mike is a lawyer and consultant who you've heard from often on these webinars. He's a frequent presenter and author on emerging legal technology and privacy issues, and he is an adjunct professor at Michigan State University. Mike, it's a pleasure to have you back as always.
Well, thank you, Robert. It's a pleasure to be back. Great to do these.
All right, so before we get started, I want to encourage everyone on the call to ask questions if you have them. We'll try to set aside a few minutes at the end, and we'll fire those questions off. You can ask questions by chatting them into the questions box that you see on the right side of your screen. Okay, so some of you who are on the last case law webinar update will remember that we touched briefly on a case in the Eighth Circuit, Ronald Perez versus H&R Block. And in that case, the prevailing defendant moved to recover e-discovery costs after the plaintiff's claims were thrown out on summary judgment. The case has since settled, unfortunately, so we don't kind of know what would have happened there, but the defendants had argued that they were entitled to the e-discovery costs in part due to the fact that they had incurred those costs to produce ESI in the format that the plaintiff had requested, as Rule 34 allows. And we also mentioned that there was a growing consensus, at least in recent decisions among the circuits, that prevailing parties are entitled to recover the costs associated with producing ESI in specific formats. So, Mike, with that, I'll turn to you to explain this idea that you coined of the Rule 34 compliance tax.
Yeah, and in a way, I see it as the trap. Hence, Admiral Akbar from Star Wars screaming, "It's a trap!" The problem becomes if we have a penalty under Section 1920, subsection 4, for requesting a specific format, even if that format is a standard e-discovery format like TIFF plus load file. That interferes with the party's right to select their production format. And the reason a party wants to select a particular production format is because that's going to let them get through the documents fastest. And so you shouldn't have to balance out those interests. You shouldn't have to avoid a trap. And as we're going to see, many courts are good at keeping that trap from happening. But there's some courts that are kind of setting up that trap, and that's unfortunate. But to do this, we really need to start back at the beginning and what this rule is all about.
Yeah, so Mike, let's kind of set the stage here. Let's turn briefly to the mechanics of cost recovery. And we'll look specifically at the intersection of Title 28 of the United States Code, specifically at Section 1924. We'll also see how courts have interpreted 1926 in a way that kind of bears directly on this. How that subsection works with Rule 54 of the federal rules. So, Mike, I'll turn it back to you to talk about what we mean by the American rule, and then we'll bring in the judges as well to talk about some of the exceptions to this.
See, the great thing about the American rule in terms of who pays for litigation costs is, in America, each party pays its own costs. It's really quite simple. Except, of course, we're going to have exceptions we're going to talk through, and but the fundamental point is, if you sue somebody or somebody sues you, you pay your costs, even the eDiscovery costs. Now, this is not typically what we see around the world. In fact, even within the system from which our legal system is derived, the English common law rules, it's loser pays. If you bring a case and you lose, you end up paying the defendant's costs. Or worse, someone can drag you into court and force you to pay their costs if they win. That's one of the reasons why, by the way, in England, defamation suits, in addition to the fact that it's a lot easier to win that kind of suit, are real dangerous. Someone can drag you into court for writing something about them, and then if they win, you not only have to pay, you have to pay all their costs. This is seen by academics and folks who are in favor of the American rule as kind of holding back people from getting access to the courts. It creates another reason to be nervous about getting involved in a lawsuit. But as we see, there are lots of exceptions. And so I'm going to hand it off to Judge Conti to talk about some of the substantive ones.
Yes, there are a few statutory provisions that I want to go over with you. One arises on what we typically call the whistleblower law, which would be 31 U.S.C. Section 3730. This relates to civil actions for false claims. And in that part, there's an award provided to a qui tam, that's what we call those types of cases, qui tam plaintiff. And the statutory language says that any such person shall also receive an amount for reasonable expenses, which the court finds to have been necessarily incurred, plus reasonable attorney fees and costs. All such expenses, fees, and costs shall be awarded against the defendant. But there's also a part to that says that because the government would have the right to bring the action, and it says if the government does not proceed with the action and the person bringing the action conducts the action, the court may award to the defendant its reasonable attorney's fees and expenses if the defendant prevails in the action and the court finds that the claim of the person bringing the action was clearly frivolous, clearly vexatious, or brought primarily for purposes of harassment. So here it is mandatory payment of attorney's fees and expenses and costs if the plaintiff in the qui tam action prevails, and it's discretionary if the defendant prevails and the action is found to be frivolous, and those kinds of descriptions that I just provided to you. We also have provisions for civil rights actions, and this is you'll find in 42 U.S.C. Section 1988, and this provides that the court in its discretion may allow the prevailing party, other than the United States, a reasonable attorney's fee as part of the cost. So here the court has discretion to award attorney's fees and costs to a prevailing party. Most people think it's just the plaintiff in these types of cases that may recover their attorney's fees and costs, but I've had cases where the defense has also requested it. But again, it's a matter of discretion. In patent cases, and this has gotten a lot of play recently, 35 U.S.C. Section 285 provides that the court in exceptional cases may award reasonable attorney's fees to the prevailing party. And recently, the Supreme Court has given more teeth to decisions by the district courts in this area. So this is another one that would apply, and you can shift attorney's fees to the prevailing party. Title VII. It's also applicable. These will be the employment discrimination types of cases. This section, 42 U.S.C. Section 2000A-3, and it provides that the court, in its discretion, may allow the prevailing party, other than the United States, a reasonable attorney's fee as part of the cost, and the United States shall be liable for costs the same as a private person. So if you're not the United States, you can get a shifting of fees and costs if you're the prevailing party. It's mostly discretionary. Oftentimes it will not be imposed against the defendant, but I have had cases where defendants have come in and requested the shifting of the payment of the attorney's fees and all other costs and expenses associated with the case. And what you may all not know is that in the federal courts, for the most part nationally, the civil rights cases, the employment discrimination cases, you have the same fee shifting for ADA, Americans with Disabilities Act, age discrimination cases. All of those comprise probably about a third of the caseload of the federal courts. So it's a substantial portion of federal litigation that could have the potential for fee shifting.
All right, so let's turn to the procedural exceptions, because it's not just substantive exceptions. Judge, can you tell us about Rule 54D and how that works with Section 1920, subsection 4?
Okay, well, Section 54D does provide, that costs can be awarded, but it's limited by Section 1920, which limits it to various certain things. Under 54D, the court can order costs other than attorney's fees to be allowed to the prevailing party. Section 1920 provides that the only kinds of matters that may be taxed are fees for exemplification and the cost of making copies of any materials where the copies are necessarily obtained for use in the case. And this has been a matter of debate among the circuit courts over the last several years, starting with a famous case from Third Circuit, Race Tires, which originated in my district. So it's really a question when you look at eDiscovery. How does eDiscovery fit into copying, making copies? What are the costs associated in eDiscovery with making copies? So that's the issue that we have now today, and it was really made quite clear in the Supreme Court decision in Taxation that this is meant to be very ministerial and quite limited, so that when you look at the Supreme Court's narrowing of this matter, the court said that, this is from the Supreme Court, the discretion granted by Rule 54D is not a power to evade the specific categories of costs set by Congress, and that is instead solely a power to decline to tax as costs the items enumerated in Section 1920. So the only costs you can get are the costs set forth in Section 1920, and according to the Supreme Court, 54D is just a matter to even further reduce those costs. So it's limitation on the power to, it's a power to decline, not a power to evade.
Yep. Well, thank you, Judge. And again, it's this making copies part that really creates something of the difficulties we're going to see, and in a way, the split between the federal circuits. Now, certainly one thing is clear. It's got to be costs related to something used in the case and not just for convenience of counsel. In addition, it needs to be something that creates those copies, not just the ancillary costs and the preparatory costs, but as we'll see, I'm actually quoting a federal circuit case here where this is from. Even in this CBT Flink case, we'll see later that the courts have, or maybe they should say, take a certain leeway on how they see what is ancillary versus what is making copies. Now, 1920 subsection 4 was a pretty obscure section in some ways. We didn't hear a lot about it, but then recently we've had a big push to try and rein in litigation costs. That was part of a series of cases by the Supreme Court in Bell Atlantic versus Twombly, seeing that the threat of discovery expenses, I should say, will push out defendants, force them to settle. And, you know, I know on these webinars sometimes we want to talk about the little guy and the underdog, but everybody's got a right not to be forced into spending a whole bunch of money in court to have to settle early. The big corporations, the small corporations, the people, they've all got their rights. They have to be protected. And that was really key to these decisions. And as we've seen, at the same time, there's been a focus. The 2012 RAND Institute study that I think probably everybody on this call knows, the famous one saying eDiscovery costs are out of control. In fact, in that study and some other ones, it was proposed that potentially in litigation, 50% of your costs are going to go to eDiscovery, that big corporations are spending quite often millions of dollars on eDiscovery. And so what this led to was some cases early on around that time that the courts were taking kind of an expansive view. As Judge Conti said, this is, they're supposed to look to try and decline the opportunity to tax costs. They're supposed to look to enforce the very specific strictures of 1920. And instead, things were kind of expanding it. And that brings us to the case that the judges mentioned, the one that started in her district, Race Tires.
Okay,
and so
Tires is a decision that dates from 2012. This was a very contentious case. It was not my case. It was a case of another one of the judges on my court. And at the end, it went to, as these cases do, for the award of costs when the prevailing party requested over $380,000 worth of taxable costs. The bulk of those costs related to eDiscovery, and the clerk of court reviewed everything that was submitted and made a determination that the award should be in the amount of $365,000. The appeal went to the district court. The district court authorized that award of costs, and it went up to the Court of Appeals for the Third Circuit. I do commend the opinion to you because it's very good in terms of going back into the history of Section 1920, explaining the historical context, how the practice of the law has evolved and developed, and putting it all into a modern day context. At the end, the court only awarded $30,370.42 in cost. So that was quite a big difference between what the district court had awarded and what the Court of Appeals awarded. The Court of Appeals, like the Supreme Court in Tamaguchi, said this is very limited, very narrow. It's supposed to be a ministerial task, very easy to look at, and found only two types of cost taxable in the eDiscovery world. It is scanning or file format conversion. That was it. That was all that could be recovered for costs under Section 1920. So it was very limited. And we have now had another case that came up in our circuit. Again, it originated in my district, and again, it was with another judge. And this was another case where there was a fairly large award of costs with respect to eDiscovery. And the Court of Appeals, when it went up to the Court of Appeals, this is Camisi versus UPMC, the Court of Appeals said, we don't have enough information about the cost. It wasn't detailed enough because the only thing you're going to get in the Third Circuit are the cost of scanning and file format conversion. And unless you can prove that the items that you're seeking fall into those categories, you're not entitled to it. So they remanded it back to the district court. The parties have now submitted proposed findings of fact and conclusions of law in terms of what the costs are. And there's going to be a ruling likely prior to October of 2017. So it's back in the hands of the district court, but with the clear instructions given from the circuit about what the limitations are on the award of costs.
And as Judge Conti mentioned, Race Tires has been very influential. It has also made it clear that there's very limited room for recovery on two particular types of eDiscovery activities. Now, it's tended to operate in conjunction with, as also Judge Conti has mentioned, this Taniguchi case. In fact, Taniguchi is a pitcher for the Yokohama Giants who fell through a walkway at a resort in Saipan, sued. Case went along. In the end, there was a need for an interpreter, and while this wasn't subsection 4, it was subsection 6, which deals with interpreter fees. Again, the Supreme Court absolutely emphasized the narrow scope of taxable costs limited to minor incidental expenses, not the kind of thing you expect to generate a $365,000 bill like what happened in the district court for Race Tires. And so some of the circuits have been following this. The Fourth Circuit followed it in Country Vinter of North Carolina versus E&J Gallo Winery in 2013. A request for over $100,000 worth of eDiscovery costs resulted in a recovery of $218.42. All kinds of disallowed preparatory activities, getting to the point where you could convert the files. And in the Ninth Circuit, and by the way, Taniguchi came out of the Ninth Circuit, so they're particularly attuned to it, completely reversed another big award, disallowed all kinds of data uploading, keywording, things that were not making copies. They did remand for some consideration of professional services charges, but again, only the work that was related to the TIFFing, so that file conversion could be awarded.
All right, so Mike, now that we've established that courts, principally among them the Supreme Court, have seemingly closed the door on what we've called broad awards of eDiscovery costs, let's look at some other decisions that provide both caveats and in some cases that just kind of flat out disregard the precedent that we have just talked about here.
Yep, I mean, the last webinar we did was one where we could have had the surprises. I don't think folks were expecting any in this one, but guess what? Surprise. Some circuits have a very different view of this. The Sixth Circuit in Colossi, I think it's Colossi, I'm not sure if I'm pronouncing that right, versus Jones, Lang, LaSalle, 2015, came right out and said, Race Tires' views of making copies is overly restrictive. They seem kind of focused on how the plaintiff, who was required to produce her personal laptop, brought her laptop into her attorney's office, and instead of just handing it over to the defendant, demanded, I put that in quotes because that's the word they use, demanded that the defendant have a vendor image that computer instead of simply just handing it off. That, strikes me as pretty standard in eDiscovery. Most folks don't want to just simply hand their computers over, but the courts seem to see this as almost outrageous behavior and allowed everything. Now, the flip side of this, the costs weren't particularly high. It's only $6,300 or so, but to an individual, yeah, that could be a lot of money, particularly after you've lost. And as well, in this Fifth Circuit case, U.S. Axwell Long versus GSD Media City, the Fifth Circuit didn't necessarily change the game in terms of how they viewed Race Tires, but they did set it up in a way that makes it a lot tougher for the party opposing costs, because in this case, the defendant was able to get a bunch of costs through simply because the plaintiff didn't object to them in a specific enough way. Again, not necessarily trying to limit things. But by far the most troubling that we're seeing, if we can say that, and hopefully I'm not overstepping my bounds by saying that, is the federal circuit. Now, when they're dealing with this, when they're reviewing these types of cases, they're applying the law of a different circuit. And so we have the first of these cases, the RICO patent litigation, applying the Ninth Circuit law. Remember, this is same circuit with the DVD case and with Taniguchi. So we should be seeing limiting activities. Instead, in the first one of these for RICO, they saw the use of a review platform. In fact, it was a company I used to work for back then. It was a review platform that both companies could use to access the data, just like Logical now. But you could access it. And so the court was willing to force the losing party to have to pay for the complete use of that, even though it was hard to see how that was making copies. Now, that case didn't go too far because there was already an agreement between the parties to split the costs, which controlled. But then we get into something a lot more troubling. CBT Flint Partners in 2013, applying 11th Circuit law, they affirmed an absolutely massive award, over $300,000, actually closer to $320,000 total. And they explicitly recognized they were splitting with the Third and Ninth Circuits on that. In fact, Judge, why don't you walk us through this case, if you can, please?
Yes. So the CBT Flint Partners, LLC, was decided in 2013. So it post-dates Taniguchi, which was decided in 2012. So it already had that in mind at this time. The CBT Flint Partners said you've got to look at 3 stages of the costs associated with electronic discovery. And the first stage is the costs incurred in formatting a recoverable cost. So if you look at these here on you can see it on your screens, where there's a copying of the source media that contain the requested documents and replicating the source as a whole for the existing state. And essentially they said that that's not going to be recoverable. The second stage is the extracted documents were organized into a database. Then they were indexed, decrypted, deduped, and filtered, analyzed, searched, and reviewed. And for the most part, that stage is also not going to be recoverable. Decryption is not making a copy. The court, however, was concerned that there were some things involved in the second stage that could be recoverable. And that would be the cost for the creation of load files. And it says that the cost could be recoverable to the extent that the files contained information required by the requested production. For the most part, for those of us who are not quite experts in this field, what you're really talking about is the metadata. If you wanted to get the TIFF and then the forms and then the load file for the metadata, you can recover for that load file and the metadata as well. In the Third Circuit, you would not be able to get that. And in the most recent decision that I referred you to, the Kamesi, C-A-M-E-S-I decision by the Third Circuit, they specifically noted that they were not going to go along with the CBT Flint Partners assessment, and they were still limited just to the scanning and the file format conversion. So when you look at this, so the culling, the deduplication, the decryption, all of that's not going to be recoverable, but you will be able to recover for getting the load files. And then the other question that comes up is, what about if you just want to do imaging? You just want to image the hard drive and turn that over. In the Third Circuit, you would not get that as a recoverable cost, but under the CBT Flint Partners and a couple of the other more recent decisions by some other circuits, that may be recoverable. And so that's where the real difference lies in terms of what are the recoverable costs.
Yep, and by the way, for folks, we'll have the Kamasi case mentioned later. I've got the site and a slide later in here, so good news. Mm-hmm. We'll make sure you get that site. But here's what we've got. And by the way, thank you, Judge, because that sets up exactly where we encounter the big problem with CBT Flint Partners, which is if you focus on this making copies language, there are times where to create those load files, to create that metadata, which normally wouldn't be recoverable, certainly wouldn't be under, the race tires or Kamasi, the Third Circuit's way of looking at things, and it probably wouldn't be under the Ninth Circuit or those who are following race tires and Taniguchi. What CBT Flint Partners, the court saw there is that sometimes to produce that metadata, you have to make a copy of a copy. And so that means that now you're still making copies, even though you're kind of making this all very attenuated. And by the way, for those of us who have been living in the eDiscovery world.
This is Judge Conti. I'm going to step away for 1 minute to address something with the jury.
Okay. And folks, that was just something we knew might happen. So thank you, Judge. We'll keep going. When eDiscovery, for those of us who are living that life, we know that, everything could be a copy of a copy of a copy. It turns into eDiscovery Fight Club in a way. And that creates a big problem because, even though you've got a couple of steps here to create this making copies scenario for the Federal Circuit, they didn't see the difference in whether you had to take one step or two step. What about 3 or 4? That brings us to a potentially tough situation. And so the court recognized where they were heading, actually. And the sad news is they seemed really kind of not to care. They said, look, in some ways, for the parties that are dealing with eDiscovery, they've got a choice. They can decide to request a production form that increases those copying costs. You can see where we emphasize this, while saving on other litigation costs, which I guess you could do the flip side. Have to increase your other costs while saving on it creates a choice. Do you want to have an effective, efficient review? Because that's why you're picking a particular form of production, so you can review it more quickly and risk getting hit with bigger costs in the end, or vice versa. That's not a very good choice because it puts you down to saying, do I want to have a really good system that I can review these documents fast, get through this thing like a dragster, or do I want to take it slow and increase my review costs? That's not a very good choice to have to make. And so, the crazy thing is, it brings us to the dissent by Judge Kathleen O'Malley, who saw this problem and saw why it was a problem, which is that there are all kinds of ways in eDiscovery that we can cut down on costs. There's all kinds of legitimate means that should be used. You're back?
I'm back. I told you it would be quick.
Oh, okay, cool. I will let you pick up with Judge O'Malley then on slide 33.
Yes. Judge O'Malley is a very well-known judge. She used to be a district judge, and I think that also brings her a little different perspective while she sits on the Federal Circuit. And she was very clear in saying she concurred in part and dissented in part, and the part that she dissented in is the part that we're interested here today. She was very clear in saying that she thought that the majority was really overreaching and going beyond what the Supreme Court and the language of Section 1920 would have permitted. And she said, you can't rewrite Section 1924, and you can't even address the shifting of the costs because of a particular electronic format that's being required. And she says if you really want to get your costs recovered in a broader way, you need to get it to the court earlier. You have Rule 26 now, which just says what the courts have always known, is you can shift costs. You can come in for a protective order. You can say it's going to be, and also in today's date, with the 2015 amendments to the federal rules, proportionality is a big issue. So it's part of the scope of discovery. So if you come into the court early on in a case and you can argue to the court it's disproportionate or it's unduly burdensome, then you can say, let's shift the cost, make them share the cost or totally shift the cost. And that's a good way to address it early. And that way you don't have parties incurring costs that they do not need to incur. We're limiting the discovery in a more prudential way to make it less expensive.
Actually, Judge, we had our last webinar, we talked about proportionality, and we have seen a big march of this, particularly after the Chief Justice wrote a couple of years ago his State of the Judiciary report that really talked up two things: proportionality and dueling. The good news is the first one's really caught on. The second has not come back. And we've seen a lot of judges who are pushing proportionality. I take it you're a big fan of that too?
Well, it is something that is now being required all around the country. Forgive my voice. It's now being required all around the country. Every judicial program that I'm going to recently that deals with case management, judicial oversight, this is being brought to the forefront, and judges are being reminded constantly that we have to be more active and aggressive in case management and getting parties in early, and also being more receptive to the arguments that are being raised about proportionality. That's not to say if you come in and just say, oh, it's going to be so expensive, I can't, it's just unreasonable. That won't pass muster. But if there is a proper presentation by the parties on the costs and expenses being really disproportionate to the size of the case that's before the court, judges now have obligations, and we're being reminded about that quite constantly in terms of what our role and responsibilities will be. We're going to have a big shift over the next several years. It's already starting. Many judges are now taking senior status. You're going to have an enormous turnover of judges on the federal level, so that we're going to have younger judges coming on board. Their initial training is all going to be under the new rules that we have now. And so I think you're going to see even greater emphasis on judges overseeing the scope of discovery and not permitting costs to get totally out of control in a case. But a judge isn't going to know about this problem unless the parties bring it to the court's attention. A judge isn't going to just jump in and start saying, well, I'm going to limit your expenses. Somebody has to ask the court to do it and has to make an appropriate case for why it should be limited in the context presented to the court. The other thing that we all need to be mindful of as we embark on this new era, as we're involved in presently, a lot of technologies are changing rapidly. There are more cost-effective ways to do things, and we need to continue to educate judges and the bar about those matters. And I think that's important to keep in mind. The way we do things today won't be the way we're doing things 5 years from now. And it's really hard to keep a pace, but it's very important to have ongoing education and focus on these kinds of issues so that we can minimize costs. There's such a concern on the national level that there's a pilot program that's being undertaken, and that's going to be coming up later to discuss some of the options that are being looked at to try to further save costs.
Well, thank you, Judge. And I'll take this next slide if you want to get a quick drink of water. these things sometimes it gets caught. It's tough doing these. So yeah, I mean, and we'll finish up with CBT by just saying this. Judge O'Malley made it clear in her dissent that not only were there excellent methods the parties could have used during the case, not afterwards when it was too late. They didn't use any of them. They didn't really discuss what they should have done to limit costs. They could have and should have come to an agreement, and then instead, at the end, tried to use 1920 subsection 4 to kind of squeeze those eDiscovery costs into it and do a cost containment too late. And the sad news is, even the two cases that I put on earlier, talking about from the 4th and 9th Circuit, that seem to support race tires and Taniguchi and this conservatism and trying to decline things out of 1920, they both have language that could also support this expansion of, again, copies of copies of copies. And, that sets us up for kind of a tough situation. It's, again, that trap. Admiral Akbar reappears. I think this is his new incarnation in the latest movie. And yes, people who attend these webinars that I do, they know I'm somewhat Star Wars obsessed. And so we've seen recently a number of cases, in addition to one that Robert mentioned early on, that have allowed pretty extensive costs for eDiscovery recovery after the case, and for things that are not anywhere near what you would expect to be recoverable under race tires, for not just tiffing, but for services, for predictive coding, all kinds of stuff that, again, very surprising, and all things that would help a party get through the review faster, but ended up costing them money in the end. And so, what does this mean for you? Well,
yeah, and Mike, just to go, Mike, let me jump in just real quick. I would commend everybody to read that comprehensive addiction treatment center case. If you go back to the last slide, that one is particularly interesting because it allowed, as you mentioned, all costs for everything associated with eDiscovery, including the cost of preservation. Thus far, we've been talking mostly about kind of things that are related to production and some collection stuff. The preservation piece there is really interesting, and I don't think that case was appealed. So a really interesting case.
So Robert, I stepped on your transition here.
No, so with our remaining minutes, and we do have about 15 minutes, so if you have questions, we will have time to answer them. But we'll provide some practical takeaways. Mike, knowing what we know now about how courts are treating eDiscovery costs, how should that kind of influence our behavior going forward?
Well, in some ways, it's a shame it has to influence our behavior going forward, and it really shouldn't. I mean, again, going back to the RAND Institute study, we know what the biggest costs of eDiscovery are. It's review. And in fact, that study was made in 2012, back when you had processing costs of $400 or $500 a gigabyte, which I know, Robert, I'm not going to ask you to talk your prices on the webinar, but we know that's way more expensive than anyone would get today. So it's probably even more so for the review, because processing and collection have gone down. So if we're going to try and push back on eDiscovery costs, we want to push back on the review side. We want to pick the race car, the dragster, not that bike with really big dragster tires. That's one of these things I just found. By the way, no, these are all Hoosier tires from Race Tires. We want to pick the things that cut our costs, not burn money. Otherwise, we get into almost a cynical approach where, look, document everything. Get a signed vendor affidavit, which, by the way, is pretty much part and parcel of what you need to have a chance of winning, even though in XRL Long in the Fifth Circuit, they won with an affidavit from their attorney. Typically, in these cases, we see you're going to need something from your provider. Make it detailed. This is, by the way, where you get the site for Kamasi. It was reversed and remanded and sent back and will soon be redecided because the vendor affidavit, again, didn't have sufficient details to show that the activities were making copies. And of course, well, you call everything copies, copies of copies of copies. And so let's keep in mind, there's a, it's up to the other side when you present this bill of taxable costs to object and disprove it. Your first review won't be a judge. Again, as Judge O'Malley pointed out in her CBT Flint dissent, that's the way this statute is built. Congress made it narrow so that the clerks could review it, and it wasn't supposed to have to go up every time for judicial review. And then, I hate to sound cynical, and this will be the chance for Judge Conti to tell me maybe I'm being too cynical. Maybe the judge will approve it. And, we've seen some of these, and we have to wonder, is this because of a lack of guidance in the statute? Is it because eDiscovery is so new? Is it because those younger judges aren't here yet? I mean, why is that? Why are we seeing this kind of stuff get approved, Judge?
Well, I think it's because there's a great reliance on the clerk of court. And when these objections come up to the district judge is looking at it and saying, well, my clerk of court has approved this, and why is it that it shouldn't be allowed? And unless you do a very good job of explaining to the district judge why the clerk of court made an error, you could be in some difficulty. We still have a lot of judges that are not as comfortable and familiar with eDiscovery. They wouldn't know what it means to have the metadata load file and what it takes to to have that. What's the difference between culling and deduping, and all of those things in there are somewhat foreign to many judges. And so when you start talking about it, if you're not able to describe it sufficiently for the court to really understand why it should be or should not be included as costs to be awarded, you could lose. And so that's the risk that you have. And we are making steps across the country to better educate the judges, to make them more comfortable with these issues. So you still have debates going on around the country. And the very fact that it's different than making a photocopy. It transition here in the judiciary, and this will become less of a problem.
That is a good thing. And by the way, as Judge Conti mentioned, the technology is advancing here. Technology is always advancing, crazily sometimes. And so we're seeing all kinds of different ways that the technology is helping us to solve this problem. And first of all, I know we all start in the eDiscovery. You start with the EDRM. In fact, in the law school classes I teach, I make my students memorize it. They have to draw it on the final, which at the very least, you should all be glad you don't have to take those finals. But, where is early case assessment on the EDRM? It's not there. We're now seeing things blending together. Is identification really a different part than we see it all coming together as well as we see this advancement of cloud computing because of the costs, the savings that it brings, because of the incredible power that it brings. We're seeing in many ways an ability for corporations to store their data out on the cloud in a way that is far more secure than they ever could store it themselves. And that means when you've got eDiscovery systems out on the cloud, all you need to do potentially is to point those eDiscovery systems at that data. The preservation is all in place. It's on the cloud. There's not really a collection. It's not being moved, and it may not even be technically processed. So again, we're seeing this collapsing of these concepts within the EDRM. As well, because of this collapsing, more and more companies are simply saying it will cost you X amount of dollars per gigabytes to do this. And so instead of getting those detailed bills, I used to go over those back, 10 years ago when we would break out all kinds of crazy stuff. Now it's X amount of money for this amount of data. And actually, Judge, if I bring you an affidavit from a vendor on a 1924 motion or seeking taxable costs, and I just put in there, a dollar amount per gigabyte, am I going to get anything?
Probably not in the Third Circuit because it's not broken out. I mean, if you can give an affidavit that says we gave a flat surface just for scanning and converting, then that would be okay. But if it's for all the services rendered in connection with this, the processes leading up to the conversion, then you're not going to get it in the Third Circuit. And I think you're going to be hard pressed in some of the other circuits as well, because remember I told you there, even in CBT Flint, those cases that follow that, they don't allow deduping. They don't allow, some of the other things that would be probably part of the background of getting ready for your production. So you got to be careful. And if it's too much of a hassle for the vendor, and if you require too much detail for them to do with this, keeping track of these things and the costs associated with it, maybe it's cheaper just to get the flat fee and forget about recovering the cost. But if you want the cost, you'd be well advised to get some detailed breakout.
All right, thank you. And then finally, and we're seeing, again, I know I'm not supposed to toot the horn of logical too much on these, but I will do it for this one. We're seeing production in place. We're seeing the ability to say, okay, to the other side, come and get your eDiscovery data here. We're not going to send it to you on a hard drive or DVDs. We're going to keep it on this secure platform, which, by the way, for just cybersecurity reasons, now you know where the data is, where it's staying, and that it's secured, and you're not just handing it off to somebody who may not have a very secure environment. It stays in place. And again, that limits the kinds of copying and movement that you need. As well, judicial progress. We've seen better knowledge of the understanding of cost-cutting measures, the rise of proportionality as we've discussed, and the judge has already previewed this, so I'll just mention it and let her talk about it. This mandatory initial discovery pilot that's taking place now in two districts, Northern District of Illinois and the District of Arizona. Can you tell us, we have a few minutes left, maybe a little bit more about that, Judge?
Yes. I remember just a few minutes ago, I spoke to you about some initiatives that the judiciary is looking at to try to curtail costs. They've asked a couple courts around the country to undertake a pilot project to see if we can't minimize the costs associated with discovery. And one of the avenues they've chosen is to go to a procedure that they had used, years and years ago, which was part of the Federal Rules of Civil Procedure. And that was when a case started, each party had to turn over to the other side all relevant documents, whether they were good or bad for your claim or defense. So you just had to be total transparency. Here are the relevant documents, and just turn everything over to the other side without being requested. No interrogatories, no requests for production of documents. Just turn over all the relevant documents. That's a model that they've, and they've been following it in the state courts in Arizona for a few years as well. So there's two districts that signed up for this. One is the Northern District of Illinois, and the other is the District of Arizona. And now they're going to follow that and see if it's going to result in cost savings. And then if it does, and we're not successful with the case management techniques and the proportionality that has been now has a level of prominence in our rules of civil procedure, if we're not successful in curtailing costs through what we have presently, I think you'll might see this come to pass, where it could be mandatory across the federal courts.
All right, you heard it, folks, from the judge. A final note before we get to questions. We have just a few minutes left. It's actually a question for you all in the audience, or actually maybe more a request. Logical loves to do T-shirts, and they do really great T-shirts. Can we all, if you put in your evaluations, put in there a note, please do a T-shirt about making copies like the old Saturday Night Live thing. It's just a request straight from me, not from the judge. Don't have to blame her for that, but I think we should see Logical do it. And with that, I want to make sure that I thank you, the audience, for attending. I thank Judge Conti for her great comments on this, and I'm going to turn it back over to Robert for questions.
Thanks, Mike, and we'll be sure to make that T-shirt specifically for you, not for broader consumption. Judge, we have a question specifically for you, and it's about kind of when you make cost-shifting decisions. In those instances, whether it's at the conclusion of a case or sometime before then, how do you verify that the cost assessments made by the party making the argument that eDiscovery costs are disproportionate? How do you verify that those are legitimate claims? How do you verify those claims?
Well, typically you'll have a hearing, and the parties will come in. You'll have generally some type of an affidavit at a minimum from a vendor, which will give an estimate of the cost. And when I've had these in the past, sometimes it's like peeling an onion, and you have to maybe go through several iterations of that, because if they lump everything together, you can't quite figure out what's driving the cost. And then you ask them to refine it and give you some more information and more detail. So ultimately what the court is looking for is a good faith estimate of what the actual cost would be with respect to the proposed discovery. And hopefully your vendor that you would normally be using would be able and willing to do that for you. If you cannot give any kind of detail, I have some situations where they come in and they say, oh, we're going to try to do this mostly in how people, and they're going to have to just focus on doing this and try to give a breakdown of the costs and the diversion from the regular business practices. Sometimes that might be okay, but it has to be definite enough. It can't be just like a guess. Well, what do you base it on? Did you have something similar? What did you do before that would cost this? Because if it's an internal assessment, it's a little more difficult for a court just to blindly accept the dollar number without understanding how you actually came to that number. And the big factor is always that I get this question all the time. How do you value the case? If I say it's worth nothing and it's going to cost me $2,000 to produce some discovery, isn't that disproportionate? To say it's worth a lot more than that. Maybe it's $100,000. So you have these wide disparities in the views of the parties about the value of it's worth $100,000 and it's going to cost you $200,000 to engage in the discovery. Well, that's a pretty good argument for disproportionality. Sometimes if you can just focus on what the other side is saying the case is worth, it can really help you. Now, if you get in a situation where you think the case $100,000, it's going to be $50,000 to produce and comply with the discovery request, then you have really to is not 100,000. Maybe the case is at best worth 15 or 10 or 15, and then you may need to get an early neutral evaluation and have somebody come in and give you a neutral valuation of what the case would be. So I think you need to think along those ways. You have to give a court some methodology for valuing the case and making your argument as to why the costs of discovery are disproportionate.
Judge Conti, I want to thank you so much for being here and for spending your time with us and for all the great lessons that you've imparted to the audience.
It's been a pleasure to be with you all.
And Mike, thank you as well. It's always a pleasure. And thank you to our audience for joining. If you missed any part of this presentation, we will post it in the next probably 24 hours to the Logical blog. You can also get the associated slides there. So thank you all, and we will see you in a couple weeks. Bye.